We welcome you to our court. So at this time, I will call the first case on the docket. This is Brian Paul Kelly and Catherine Lynn Ferguson, trustees of the Paul Wayne Kelly Trust, and Catherine Lynn Ferguson, individually appellees. Lawco Holdings, LLC, a limited liability company appellant, a case out of Cowley County, Kansas, case number 128610. Would counsel for appellant please enter your appearances?
Chris Steinkamp with Pugh, Gillen, Rathman, and McIntyre for appellant Lawco, and I have Aaron Lawson, the Chief Operating Officer of Lawco, at the table with you.
Thank you. And for appellee?
Thomas Rhodes, Your Honor, Wichita, Kansas. Here on behalf of the appellees, the plaintiffs in the district court case.
Very good. Thank you. And so I think we will pause here to just review our procedure. I think most of you are familiar with this, but each side will receive 15 minutes for oral argument. The appellant is allowed to reserve a portion of that time for rebuttal. Would the appellant like to reserve?
Now, if I could, 5 minutes.
That is granted, and our timer will set the clock accordingly. So 5 minutes, there we go. Perfect. All right, counsel for appellant may begin.
May it please the court. First, I want to thank you all for adjusting your docket at my request to accommodate my schedule, so I appreciate your courtesy in that regard. This matter arose out of, I think, a little bit of perhaps misunderstanding and perhaps some sour grapes on behalf of the plaintiffs. The lease that is at issue here was signed by the current plaintiff's parents, Paul and Diane Kelly, and was given to Lawco's predecessor in interest as well.
Counsel, we're familiar with the facts. Let's
Okay.
get right to it.
Okay.
You don't have much time. You've got 10 minutes to convince us why the
understand.
district judge was wrong. So how did the judge get it wrong?
Okay. The district judge, first of all, there are really a couple of issues. One is whether or not this oil and gas lease is producing in paying quantities. Lawco's drilled 3 wells on this property that have been producing oil since about 2014.
Now, this is a unitized lease.
It is
There's been no wells drilled on their lease, but because it's unitized, it's included in the group, correct?
correct.
So
The
when you
effect-
say there's wells have been drilled, you don't mean on their lease, but you mean on the unit.
On the unit, correct, Your Honor. And the unitization, the effect of that is to treat all of the leases that are unitized as if they are one lease.
And so by proportion, they got, now.
Right.
The problem, it seems to me, when I read your briefs, is the year 2020.
That has been an issue, Your Honor.
Well, tell me, how much oil did you produce on the unit in 2020?
The oil was produced approximately equal to the amount that was produced in the prior year and the subsequent year. It was not sold. And the reason it wasn't sold is, as you may recall, in 2020, the world was shut down, including all of the courts, from March of 2020 until about March of 2021. Lawco had a tank that is approximately twice the size of what you might typically find in that area of the world on this lease, because one of the wells that's drilled there is a horizontal well and it produces a lot of fluid. So Lawco was able to store the oil in that tank for the year of 2020, even though they were producing it out of the ground, and they sold it in 2021. The data for that is in the court file and is in front of the court. And the volume is about twice.
Just to pause for a second. So I think the appellee's position on that point is the quality of oil that was sold in 2021 doesn't really reflect that it was their oil because it was of a lesser quality. Can you address that point?
I can. Actually, I don't believe it was of a lesser quality. What it was is that the purchaser, Coffeyville Resources, which is relatively local down there, has a policy that they don't take oil that's been in the tank over a year. And so it was sold to a reclaimer, but in the court records, there is a breakdown of the oil, which is very typical of the oil that was produced before and after it. It only has about 3% of fines and water and different things like that, which is typical of normal oil production. So there really isn't a quality difference. The plaintiffs have made a point of trying to argue that, but they don't really have any evidence that supports that because the evidence from the purchaser is that it's typical of normal oil.
Well, the heart of this case, isn't it, that the reason why this lease is going on is because the primary terms expired and now it has to be produced in paying quantities for the habendum clause to be operable. Is that correct?
That is correct. It is in the secondary term, Your Honor.
And because of that, the question is, has there been paying quantities? And the district court said no.
Well, interestingly, the district court calculated that it did, in fact, even with the district court's calculation, make $19,000 over the period of time that the district court determined was appropriate, which was from 2016 to 2022. Now, the math from Lawco is it made about $45,000 for the period of time that it's been operated. The district court did not consider the first year of operation, 2015, but the calculations are specifically that it made income of $62,105.13 and had expenses of $42,879.64.
And what kind of royalties did the plaintiffs receive?
Well, the plaintiffs were paid royalty based on their proportion, which is, I believe, the piece of the unit that is the lessors are entitled to is, I believe, about a quarter of the total amount of royalty. And once
So can you answer my question? How much did they receive?
dollars,
Yeah.
I don't know, Your Honor. I believe probably about, I'm not sure. Do you know?
Your folks paid them. I mean,
Well, actually, my
Your-
folks did not pay them. The purchaser pays them. Coffeyville Resources pays them. And one of the things that started this was that they didn't update the records with the purchaser. And so the purchaser put their interest in suspense. And so there was money in suspense that they hadn't been paid, and they thought they weren't making any money at all. When in fact, once they updated the records, once Paul and Diane Kelly had transferred it to this trust.
now, when you say they didn't update their records, to whom were you
The
referring?
plaintiffs. The oil and gas lease at the bottom of the first page, and these are not numbered paragraphs unfortunately, but the oil and gas lease puts the burden on the lessors to maintain current addresses and title information with the oil and gas purchaser, which these plaintiffs did not do. And once they did do it, they were paid, and they have continued to be paid since then through very recently.
Now, counsel, I'm interested in your argument concerning the cessation of payment due to the low price of oil and how that relates to the prudent operator standard. Could you elaborate for me?
Certainly. The issue here is when the price of oil in 2020 was for a significant amount of time negative, you had to pay somebody to take your oil. And the reason is because the world was shut down, nobody was using oil, and all the tank storage was full. So I don't think that the law requires the oil and gas operator to be prudent by paying somebody to come take their oil. The Collins case, which is cited in our brief, says that low prices justify not producing and selling oil during the times of the low prices. We were in fact producing the oil, we just weren't selling it.
But what proof do you have of that?
We have affidavits from the two pumpers that pump this lease that they're out there every single day, and they filed affidavits in this case that says, yes, this unit was continuing to be produced throughout 2020, we just weren't selling oil.
But there weren't any records to quantify that or support
We
that.
don't have the pumper records on that, frankly, Your Honor, but I mean, we do have the human beings that were doing it who have signed an affidavit under oath saying it was happening.
But then to controvert that, I think Police cited some Cali County records and then the Kansas Geological Surveys. And so their calculation was, I believe, like it was producing 0.65 barrels per day. How do you respond to that evidence?
Well, I respond to that evidence by saying we have the evidence from what Coffeyville Resources was paying us. I can't tell you how they came up with their calculation because I frankly don't think it's correct.
And I'm going to stop you there. So we've talked a lot about production. I want to shift for a second to exploration. So if I understand, under Kansas law, there's an implied duty in every oil and gas lease to explore or develop. And so, they are citing an affidavit from your CEO where he is saying they have no additional plans to drill or explore wells on the Folsom unit or the Kelly lease. Is that correct?
That he said they didn't have any current plans to drill. He didn't say that they never intended to drill again. They are operating prudently, producing oil, and as the production and as the economics dictate, they will drill additional wells. So the plaintiffs relied heavily on a affidavit from a Mr. McGowan, who claims to be an oil and gas operator in Kansas, and he claims to operate a company called McGowan Oil Company LLC. The problem with that affidavit is McGowan Oil Company LLC is not a licensed operator in Kansas, and so it's false on its face. There is another company, there's a McGowan family partnership that is an oil and gas operator. The difference is that he didn't cite that, first of all. And second of all, that company has produced about 1,000 barrels of oil since 2014. Lawco has produced 247,000 barrels of oil over that same period of time.
But not on this lease.
But not on this lease, but they have continued to produce this lease, and they show a profit of $50,000 over the period of time that is relevant in this lawsuit. $50,000 meets the standards of paying quantities, and a prudent operator in Kansas, if you make money, in spite of what the trial court found, just making money does not require you to continue to drill more wells. It is when you prudently can drill wells for both your own benefit and for the benefit of the lessee is when you should drill more
What
wells.
evidence is there that withholding the exploration and further drilling is prudent in this particular case? Was that ever addressed in those affidavits?
The prudence is that that Lawco has spent, frankly, several $1 million drilling these wells, and they are entitled to have some hope of recovering their money. And they have also spent a lot of money evaluating this geophysically, which is covered in the affidavit. And they don't believe that there is a hot drilling location on the Kelly's property that is something that they want to drill right now.
But that was shared with the district court?
It was shared with the district court. That affidavit is before the district court.
The conclusory affidavit, but the exploration logs were not part of the record.
Well, they did not provide a copy of the seismic itself, Your Honor. I mean, it is proprietary to Lawco, and I mean, frankly, it is.
So you can say one thing and it's secret, so we can't read it, but you can say that's what it is.
Well,
How's that any different than McGowan saying, well, I'm a producer?
well, it's different because unless you are a petroleum engineer or a geologist, I don't know if we gave you the seismic, it would necessarily mean anything to you, frankly. And it wasn't relevant to show you the actual seismic readings itself. I mean, that's a geophysical log.
Was that your choice to not present that?
It wasn't my choice necessarily. It just didn't seem like it was necessary. The plaintiffs presented no evidence on any of the factors required by the law that require further development. They did not analyze anything or provide any evidence about any of that beyond the fact that, well, you didn't drill any wells on the Kelly lease. And there is a number of Kansas cases that say, from this court, in fact, that say, just saying you didn't drill a well out here is not enough.
Thank you.
Any further questions? Thank you.
Thank you.
And we will give you some extra time. Okay. You may proceed.
I won't belabor the facts here, but I do want to stress that this lease, again, this lease has been in effect for over 10 years. It had been in effect for over 10 years at the time the lawsuit was filed. And there had been no wells drilled anywhere on any part of the lease during that period of time.
But that's okay, isn't it, since the Folsom unit was included in part of that
That
legally? I mean, just as a matter of law, nothing per se is illegal about that fact, correct?
actually there is, because to the extent that Lawco contends that production from the Folsom unit was profitable, they had an affirmative duty to explore and develop the remaining acres in the Kelly lease.
That
So
obligation is to the entire unit, not just the Kelly lease, but that obligation is to the
Absolutely.
entire unit, right?
absolutely, and we may be before you on that at a future date, but
And how many acres were pulled into the unit and how many remained in the Kelly Trust?
there were 1,462 acres in the original lease, 160 of which were included in the unit. And there was 1,322 acres that were untouched by Lawco, at least as far as drilling and actual well exploration is concerned.
You mentioned profitability, but don't you have a dispute between the facts here as to what amounts should be included in costs so that you determine profitability? It seems like the parties, talk about, well, do we have to include this or the insurance costs and the overhead and things like that?
Correct. There was some discussion about the fact that insurance, for instance, is not a cost to Lawco because they're self-insured. There was some debate about the fuel costs associated with operating the one well on the Folsom lease that was producing, because Lawco contends that they didn't have to buy propane to run that well. They could get they used the natural gas produced from the well, but that wasn't consistent. I mean, at some points they used the natural gas for the well, and at other points they did not. So it's hard to tell, and it's hard to really to believe that the well, if it was capable of producing sufficient gas to run the operation, that it did do so over the course of its production. But in any event, that was a debate. There was another debate about the fact that during the year 2020, Lawco showed expenses for a pumper to maintain the lease for only 2 months of that year, and indicating that the lease was unattended for the remaining 10 months of that year.
Counsel, I've got a question about 2020.
Yes, sir.
According to what I read, there was no production
Correct.
on the lease, the unit. I'm going to say the unit
Right.
for the year 2020.
There was
Although
there were no sales.
there are no sales. That's probably more accurate.
Right.
There was some sort of production put in large tanks, but nothing was sold.
Correct.
Now, I think all of this is governed, is it not, by the prudent operator standard? If the price of oil is so low that you can't make a profit, why would it be prudent for an operator to sell at a loss?
I don't think it's necessary for the operator to sell at a loss, but it is necessary for the operator to consult with the lessor and explain to them exactly why they're not producing the well that holds their property.
Is there anything in the lease that requires this advisory to consult with them? Because the operator of the lease is the operator of the lease, and the leaseholder is the leaseholder, and one doesn't do the other.
No, but it is a cooperative venture insofar as the lessor is allowing the use of the exploration and development of their minerals, and the lessee is operating to fulfill that that obligation under the lease.
It seems to me that this is just the inverse of the old saying, you know, a rising tide lifts all boats. Well, it seems to me the sinking tide drops all boats, and you're both in the same, there's no reason to have production if it's not going to be sold at a profit, correct?
I don't know that there's any black letter law that establishes that. I think that what the law says is that the operator has to sell
Sometimes you
production.
have to have common sense, don't you? I mean,
Okay, all right.
you don't do
that.
business to lose,
I'll grant you that.
correct?
I think that there is justification for suspending operations or curtailing them or limiting the operations to the extent it's necessary to avoid a loss.
I'm more interested in the affidavits, because we've heard comments disparaging an affidavit that's used. And interested in the exploration. These seismic, have you seen these seismic
No, I'm not.
studies?
I've trusted the word of the affidavit on that fact, Your Honor.
Has there been exploration on,
So far as they say,
Police?
yeah, they say there has been, and I'm not going to dispute that. I think that that's fine. The fact is that on the 1,462 acres, there's been no drilling. And if they're not willing to, if the exploration doesn't result in drilling, then the lease ought to be released. And if they're not gonna develop the lease because of low prices or because of whatever, because it's too expensive to do so, or because their exploration doesn't justify it, it doesn't matter. If they're not gonna use the lease for its intended purpose, they need to let it go.
isn't there a fundamental principle in oil and gas law in Kansas that the leaseholder has a right to have the lease developed?
The leaseholder being the lessor,
Yes.
lessee.
The lessor.
Lessor, absolutely. In fact, that's KSA 55-223. And the consequence of non-development under KSA 55-226 is there's authority for termination of the oil and gas lease if you breach that covenant.
It seems to me that in this case, when we look at it, we're seeing a battle of the affidavits. And that's not normally how we grant a summary judgment motion. You know, we're looking at the facts and controverted facts and comparing them to see if there's a genuine issue of material fact
Right.
about these things. And, you know, you guys have opposing affidavits with contradictory conclusions. Why shouldn't we just throw up our hands and say, well, there are facts here that are debatable. We should let it go to trial.
Go to trial. Because the facts are, Your Honor, the facts are such that they are compellingly in favor of the plaintiffs in this case, of the appellees. And that's based upon, as far as the absence of production from the Folsom unit is concerned, that's based upon the sales that occurred after the lease failed to sell anything during the year 2020. In October of 2021, after there'd been another additional 10 months of production, it only sold some 500 barrels of oil. So if there had been all this production from the lease, it wasn't evidenced by any sales. And it certainly wasn't evidenced by any production records Lawco keeps because they didn't have any. So, and it's incumbent upon the operator, the appellant in this case, to produce records necessary to show that that lease was producing, and they didn't do it. The only thing they had to show for it is some sales during the following year, and most of which consisted of these tank bottoms or oil that was sold to the reclaimer that wasn't suitable for sale to their standard
But
purchaser.
they dispute that as well. They say it's not tank bottoms.
Fine. Even if you include that oil in the calculation of profitability, it's that unit was still unprofitable for the year from the end of 2019 all the way through till 2022.
And just so I understand, so when these summary judgment, these competing motions were filed, As far as the discovery process, it was only paper discovery that had been exchanged, no depositions
deposition.
of the affiance. Is that correct?
No, then there was really, we didn't see any reason for it because we felt that like the affidavits and the paper discovery were sufficient to establish the plaintiff's case in this matter.
And then the other question I had pertains to the attorney fee argument. So, as I understand your claims, they are all based on breaches of implied duties. Is it possible under the statute to be awarded attorney fees for a breach of an implied duty under a lease?
You're correct, with the exception of breach of the abandonment clause of the oil and gas lease, which requires continuous production after the end of the continuous profitable production after the end of the primary term.
But does the habendum clause create that duty, or does it just say this is means for termination of the lease? Is it an independent duty you must keep producing
Well,
bank quantities, or is
I-
this the lease will fail if you don't?
I think that's a distinction without a difference. I mean, if you don't have production, then the lease automatically expires.
Right? So it's talking about termination of the lease.
Correct. And if it's going to expire or has expired, actually, if it's going to expire, it's incumbent upon the operator, the lessee, to restore that production within a reasonable time. Or to take steps to restore that production. And they didn't do it. In fact, they committed to not drilling any additional wells.
But you're not arguing they have an intent to abandon the lease.
I think if the lease doesn't produce in commercial quantities for a period in excess of 1 year during the year 2020, and thereafter until the sale in October of 2021, I don't know that the intent really has anything to do with it. It's a matter of did they or did they not produce in accordance with the requirements of the addendum clause.
Do you have further points you'd like to make?
Well, I had several, but I think what this comes down to, as far as the production is concerned, is proof of that production. And we have affidavits from some of Lawco's employees that's where they said they were around the unit, around the producing well during the year 2020, and it was continuously producing. And if so, that needs to be quantified, and it never was. There are cases, we cite the Eichmann versus Lavelle Resources case, as do they, for excuse me, for competing obligations. But there's another case that is important. I'm going to quote to you from the ruling of the Supreme Court in USD 323 versus CWD Investments. If the moving party shows the absence of facts to support an essential element of the non-moving party's claim, the non-moving party has the affirmative duty to come forward with facts to support its claim, although it is not required to prove its case. In this case, they didn't come up with the facts necessarily to establish. They had the burden of proving that well produced, that the wells on the unit produced during that year, and perhaps during the 10 months following, and they didn't do it. They couldn't do it.
It seems to me that your attack on this is broader than just non-payment.
It is.
It's the failure to, also the failure to explore and develop.
There's also, correct. If the Folsom unit is profitable, then there is an obligation to further develop and explore the remainder of the Kelly Trust lease, and they didn't do it. If the well in the Folsom unit is non-profitable, that obligation goes away, but then so does the Kelly lease. There's another aspect to this too that might be overlooked, but it's important, and that is, in addition to the obligation to explore and develop, there's the obligation to market the production from the lease. And as you said, there may not be that obligation if it's, could only be sold at a loss, but there still is an obligation to confer with the lessors to establish whether or not that sale or the absence of sales is going to upset the validity of the lease. There's also a requirement implied under oil and gas leases in Kansas that not only does the production have to be marketed, but that the sale of that the lessee, the operator of the lease has to prevent that lease from drainage from offsetting production.
There wasn't any trial on that below, though, at the trial court level, was there?
Well, that was certainly pled as part of our, as part of our summary
Are there
judgment.
facts admitted in the facts to the district court on drainage, the drainage?
Yes, absolutely, because there's only one, perhaps two wells producing on the Folsom unit. All of the acreage to the north along a border of 1 mile belongs in the Kelly lease. And there was no drilling on the Kelly acreage to the north of the unit to protect against drainage from the balance of the Kelly lease to the north, where the royalty would have been 4 times what it was from the Folsom unit.
But
Just due to the size of it,
I'm sorry?
just due to the size of it, it would be larger royalty, right?
It'd be larger royalty because it wasn't unitized. So there was no acreage attribution associated with the royalty calculations
Or the expenses.
or the expenses. That's right. Anyway, those are other aspects of this. Again, the requirement to market the production or the requirement to drill offsetting wells to prevent drainage only pertains or obtains when there's profitable production on the Folsom unit in this case. And if that's the case, then they breach those obligations. If that's not the case, and the Folsom unit was not operating at a profit, there is no obligation to market. There is no obligation to drill offsetting wells on the balance of the Kelly lease. But by the same token, the Kelly lease expires because it's not able to produce in commercial quantities. So.
Any other questions? Thank you.
Thank you.
Council, you have 5 minutes for rebuttal.
Thank you, Your Honor. Well, I just want to address a few questions. First of all, there is no obligation on behalf of a lessee to consult with a lessor in this lease or frankly, probably in any other lease. The lessee operates the lease and pays royalty to the lessor, and that's it. They don't have to go tell them what the seismic says or whether they're going to drill another well or not or any of those sort of things. And in fact, I would be surprised if any operator does so.
There's no duty to consult,
There is no such duty to consult.
either implied in law or by contract in the lease.
Correct, Your Honor. There is no case law that says that, and there's no contractual language in this lease or any other lease I'm aware of that says it.
Tell
So,
me, is this an old Form 88 lease?
I have it here. Hold on a second, Your Honor. I don't think it is.
All right. It's nostalgia on my part.
Yes,
Beg
no,
my-
I understand.
Your pardon, but
It is not a Form 88, Your
All right.
Honor. I think it's a paid up lease form.
you know the form I'm talking about.
I know exactly what you're talking about. So that just isn't the case. Secondly, the law in Kansas under Reese versus Lawson Prey versus Premier Petroleum, all of those cases say you don't go and look at one little narrow time period when the markets are in bad condition and decide, okay, well, you didn't produce for this little slot right here and paying quantities, so therefore your lease is terminated when your lease is otherwise very profitable. And the trial judge found that the appropriate period of time to determine profitability was from 2016 to 2022. And he also determined that it paid in paying quantities during that time period. And for the plaintiffs to now assert that, oh, we ought to just look at 2020 when the world was shut down is not the law in Kansas, and it frankly shouldn't be, because there won't be very many leases survive in this state if that becomes the law.
Let me stop you for a second. I mean, just getting back to basics, these were summary judgment motions. You know, an obstacle to summary judgment is a dispute of a a genuine material fact. Don't we have that in this situation? I mean, we've got competing affidavits, competing data. I mean, why was it appropriate for the district court judge to decide this case?
I believe, Your Honor, that the reason it was appropriate is because, and this is an important fact, you'd asked about a minute ago, there was no discovery conducted by the plaintiffs whatsoever. And the plaintiffs are given the burden of proof, just like every plaintiff. They're given the burden of proof as plaintiffs, first of all. Second of all, the Eichmann case, the Rockhold case, the Staley case, all specifically require them to prove you're not producing in paying quantities, you're not drilling additional wells, you're not meeting your duty as a lessee. They have no facts about that at all, and none exist, Your Honor. The information that was supplied by the defendant Lawco is the only information that is out there.
But I think there's a difference between saying a fact is disputed or we win because the facts are not in dispute, but the facts are in our favor. So
Well, I
which
think
of those do you believe is true for your client?
I think that the facts are in our favor and we should win because we've shown, and the judge has found, that we are producing in paying quantities. We've also shown that they have not met their burden of proof to show that we ought to be out there drilling additional wells. The trial court, at the summary judgment hearing, Mr. Rose tried to advance the argument that the unit was draining the Kelly lease, which is part of the unit. That was not pled. There was no facts about that, and the trial judge refused to even hear that argument. And I mean, I've never heard of such a thing. You can't have drainage within a unit. It isn't a thing. So
There's acres, Kelly acreage that's not in the unit because it's not even in the lease.
but it's within the lease, and it's held, that entire lease is held by production. And so
Yeah, but
if I
that's
have,
160 acres, isn't it? Or 160?
right, but if I have production on 160 acre quarter section, do I have a claim that, well, you're draining my other quarter section that's in the same lease? No, there's no such law like that ever.
Let me back up to the exploration issue. So, I mean, it's a small section of what the Kellys own that is in the unit, and then the rest of it they hold separately in this trust. So what is your duty to explore the acreage that is not in the unit?
The duty to explore has, I mean, we have some duty to explore, agree. As the affidavits indicate, and we've talked about previously, Lawco has shot seismic. They've drilled a number of wells where they believe that seismic was effective, and they've established production. The seismic doesn't indicate that the rest of that acreage is acreage that they are currently wanting to drill. As time develops, other drilling occurs, they get production information from the wells they have. Leases get developed over time because you're looking at your work as my father always said, my father was a geologist, your work is a mile away from you. And so it's pretty hard to know what's going on down there until you spend some time. And that's why seismic exists, is because it's an ability to go look down there and see what's going on. They've done that, and they've done it over a wider area than just the Kelly lease.
But that's not in our record.
It is in your record, Joe.
Well, your statements are that it exists, but those records don't exist, the seismic.
We
They-
did not
they-
provide
not in
the
our
actual seismic. You're right.
They're not in our record.
The actual seismic itself is not in the record.
And you say you've done it over a wider area than the Kelly lease. Do you mean wider than the Folsom unit?
Wider than the Folsom unit and wider than the Kelly lease, clear into northern Oklahoma, as I understand it.
It's all connected.
It's all connected.
underground.
Any further questions?
Questions?
No.
Thank you. Thank you both for your arguments today. This matter is taken under advisement. We know how important it is to get you a timely decision, and we will get that done as soon as possible.